and then a minister takes a decision to vary that in an addendum and say that she's transferring that cost and risk from the private entity to the Ghanaian taxpayer, there must be proper justification for saying, I understand that what forms the base material for my decision making is not a company's rendition and response, but the Auditor General of Ghana's report. And so long as the Auditor General of Ghana has raised questions about that payment, even if the private company thinks that they have challenges, they can have redress to the courts.
Abusia for Rebecca, a parliament, a committee sitting on Niema bebree na reveal ho. Rebecca, a ho pa na otim say a public sectors for no a figures for woman no otim say niema omo ye legally ni niema omo ye illegally ni nyina no be scanner ko di bia no ho no ye reveal niema eden e ho na ne omo dudu mu akotie si Ministry of Communication ho na ßļasts eden e Minister of Communication na ensema APP ba no true Sam George niema wo yipe no niema ehuye papa scandals upon scandals just say that ministry no in connection with some companies just say a cow ma bono I was saying this ministry ekwaji free these companies wono companies in say omu de omu ntimi omu mbo ke bia na se kanu kra ho a yenchengu Ghana taxpayers for so no muntia meanwhile wo ye bunya profit wo no percentages abani nya so mfa so what the buy no for the rest na kaba dia unso untia yen confirm koma taxpayers for no me de omuntia no na Sam George aba be release some shocking scandals akoso just wa fire expose ßļasts na omukchim say companies are true ßļasts no omo ye in connection deals in buy no some NPP some also some defend these companies some ye den you just say Sam George ego companies in animals also umbiti makokot court yes bring kunkuti this account just free Sam George
and Libara Ghana Limited signed on August 15, 2018 says that during the term of the initial 5-year period of the contract, Libara Ghana shall make an advance payment of $2 million for the first year and thereafter a yearly advance payment of $1 million to Ministry of Communications and Digitalization. Pursuant to clause 4.5 of the principal contract, Libara Ghana Limited assigned all its rights and responsibilities to Smart Infraco. We noted that between 2020 and 2024, Smart Infraco, a special purpose vehicle, failed to remit to the ministry a total amount of $6 million as yearly advance payment, which becomes due on the first quarter of each year. And then it has the years over here. 2020, $2 million not paid. 2021, $1 million not paid. 2022, $1 million not paid. 2023, same way. 2024, same way. We recommend that the chief director should recover the total amount of $6 million with interest at the prevailing Bank of Ghana rate from Smart Infraco, failing which remedies as stipulated in the contract should be activated. Minister, what says you?
Thank you very much, Chair. Chair, this contract actually started in 2015 when I served on the board of the National IT Agency. In fact, Madam Rita Shraha, who is today Managing Director, was also on the board at the time when that board approved for the then MD to engage Libara. The contract was not consummated before we left office in 2016, and the Akufo-Addo government took the decision to sign with Libara in 2018. The terms of the contract are as you have read out in the Auditor General's report. However, we have been appraised of addendums to the original contract. Addendums which have sought to alter the letter and spirit of the original contract. The original contract was for Libara Ghana, a private company, to commercialize the excess capacity of NITA, the National IT Agency. There had been about $300 million worth of investment by the John Mahama I administration. And so we asked that the infrastructure of NITA should be commercialized and there should be a profit sharing between the private entity and NITA. However, we were very clear that it should be on new business. So NITA already had a number of government agencies as its client. That business was supposed to be exempt from this commercialization because this new entity was not going to be bringing in this new business. But for example, on the Eastern Corridor Fiber, you had 48 core. And at that time, we were using less than 6 core. And so to commercialize the rest of the infrastructure, we said we needed a private vehicle to do this. There were 120 LTE base stations which we thought could be commercialized. Mr. Chair, or Madam Chair, it's become evident to us that there have been 2 addendums that have changed the contract, handed over fully the entire government infrastructure to this private entity. In fact, an SPV was set up called Smart Infraco that took over all rights of Libara Ghana. Now, I have referred this to the Attorney General for his advice. And so, but the issues we have raised for the Attorney General to advise us on is that the terms of the original contract stated that Libara could not assign more than 20% of their rights to a third party. Now, the current situation is an SPV has been set up called Smart Infraco that has taken over 100% of Libara's rights. The other issue that arises is the fact that when we took over the ministry and there was the need to change passwords for some government agencies, it became clear to me, and unfortunately my Director General for NITA is not here, he's a bit under the weather. NITA had no access to the National Data Center.
Minister, you mentioned that the terms had changed in one breath, and in another breath you also said that they had also amended the main contract. So isn't the change of terms, wasn't it as a result of the amendment of the original contract?
Exactly so, Madam Chair. But again, I leave this for the advice of the Attorney General and the lawyers, that you cannot alter the terms of a parent contract in such a manner that vitiates the intent of the original contract. Because the original contract said you could not assign more than 20%. Now you have a situation where you've done an addendum that has taken over the entire rights and handed them over. So again, that's a question for the lawyers to determine if that is legally right and permissible by our laws. But the change in the terms are on the basis of that addendum. Now the question is, against the spirit and letter of the original contract, is that admissible? The fact that it was signed, is it legally tenable? And is that's a matter for the Attorney General that we've written to. But like the point I was making was when we took over office and when I was appointed in February 2025, we realized that NITA, the National IT Agency, had absolutely no access to the National Data Center. And for them to be able to effect the changes, they needed to make a request to the private entity, Smart Infraco. That I called the meeting immediately and requested for a meeting. And now NITA has root access to the National Data Center and has fiscal access as well to the data center. On the issue of the 6 million, that was part of the original contract. Now, my understanding from the briefings we've received is that Smart Infraco says they spent money doing rectification of the infrastructure that they acquired. And for that reason, they are offsetting it against what was supposed to be deliverables to NITA. My position as minister has been clear. You have an obligation under the contract meet those obligations. Pay the $6 million to NITA. Then submit your claims for any rectifications that you did. Let that be authenticated and verified. And then let's see the terms of the contract. Did the terms of the agreement say that you were supposed to take the infrastructure in situ the way it was? Or were you supposed to take it and rectify it at the expense of the state? Those are questions that need to be settled. So this 6 million is owed the state, and we've written to the Attorney General to advise us on the steps to reclaim this $6 million. But Mr. Chair, the last point I will make is that I believe that this matter is of grave national importance, because the infrastructure we talk about is our national data center. That's where all our critical assets sit. As we speak, the country is aware of what's going on with the Ministry of Health and the LIMS contract. Mr. Chair, the Ministry of Health has reached out to us to provide some support for the stopgap measure they want to do. Now, we are being told that that contract, which is not being, or this service that we are going to render from the National Data Center to the Ministry of Health, must be signed with this private entity and payments made to the private entity. And so I have written officially to the Director General of NITA, instructing him to engage the Ministry of Health directly and not through the private entity, because the asset is the property of the Ghanaian people, paid for in full by the Ghanaian people with our taxes. And this is another government agency we are offering services to. If any payments will be made, it will be made to NITA directly. The terms of the contract must be that Smart Infraco should go and bring new contracts and new jobs and share revenue. And not that they sit back and then our government asset has been handed over to a private entity and they are commercializing it and taking all the revenue. This is what I inherited, and this is what we are trying to fix.
Thank you very much, Minister. I can understand the explanations you are giving to this committee. Our concern has to do with public funds that ought to come to the public. Whatever you are suggesting sounds to me like a policy direction that you want to undertake. When the report came before this committee, we wrote to the companies involved, and they have also given us their response. But just so we are all on the same page and we do not take this thing so lightly, I want to read to you that per the report from Smart Infraco, they claim that clause 6 required that Smart Infraco restored all infrastructure within 12 months using its own capital. They also claim in clause 6.4 that the company was allowed to deduct capital expenditure, direct cost, and taxes before calculating revenue share. And in clause 12 of the same report, it also states that there was a second addendum which overrides the original contract in case of inconsistencies. And I seem to understand your concern with changes in contracts and all of that. But with a few contract law that we've learned, there's a clear case of novation. One company, one private company moving to the other. Because they are not here, and because it also involves some legal documents and all of that, that is why we're also reading to you the response that they have given to this committee. So I want to find out from you if you have an idea of what the company is saying, and that the clauses that they claim, especially clause 6 and 12, are contained in the report. Thank you.
Thank you very much, Chair. I've just pulled out the contract, and I'm going to read the original contract, the parent contract. I'm going to read clause 4, and the heading for 4 is cost and risk. 4.1 says, save the procurement of an irrevocable bank guarantee or letters of credit Libara Ghana shall undertake the obligations of this contract project at its own cost and risk. So now this means that whatever cost was supposed to arise out of the execution of the contract, this is clearly stated here, and like you said, contract law, clause 4.1, would be at the instance of Libara Ghana, the parent company, the company that we signed the contract with. So, you see, we need to be minded as public office holders that whilst we want to support private business, we cannot do it at the expense of the Ghanaian taxpayer. So if the original contract says that any cost and risk associated with the execution of this contract is at the expense of the private party, and then a minister takes a decision to vary that in an addendum and say that she's transferring that cost and risk from the private entity to the Ghanaian taxpayer, there must be proper justification for same. Unless you show me what it is, I, as minister, with the evidence available to me, still hold the view that whatever was agreed in the parent contract, which is the 6 million we're talking about here for the first 5 years, should be paid to the tax kitty. If there are any conversations to be had about whether there's an addendum that has shifted liability for cost, we can then have that conversation. But to deprive the taxpayer of this anticipated revenue on the back of a policy directive, I think may be problematic.
See, Minister, I mean, we are not here to want to defend any past government official, and I can understand. I mean, once the new government takes over, there's a new direction, and from how you speak, we realize that probably maybe you would want NITA to take a different direction with respect to this contract. But once the state has a contract with some parties, I can see the original contract, which was signed somewhere in 2018 with Libara, is what you are making references to. But I also want to bring to your attention that in 2020, this same contract was novated to Smart Infraco Limited. And this was with approval of all parties. And of course, in terms of contracts, addendums and variations are always, they come in. I mean, we can vary a contract subject to the fact that all parties have come into a certain agreement. And I also know that you are aware, because we have with us a due diligence report that was conducted by Tata Communications Limited, and we've been provided with that report, and I'm sure it's going to help us moving forward. But so that you know that addendums in contracts are not illegal. They are not unlawful. It happens every day in contracts. And so let's speak to what exactly we have that got varied along the line, along the value chain in this contract. And I think that it will help the committee. Thank you very much.
I must also admit that in the response that they gave to us, Smart Infraco admits that they owe. So it is not like they are not acknowledging that they owe government. From their report, the report that they gave to us on page 5 of 8, it says that Smart Infraco acknowledges the outstanding amount of $1 million, in addition to a balance of 162,518, and which has been featured in the accounts and submitted to the ministry. So there is some liability that they themselves have acknowledged. But from what I read from their reports, that the addendum necessitated a change in the advance payment. You can correct me if I'm wrong, but from what I have read, they are saying that the addendum that they made to the original contract, the variation that they made to the original contract, necessitated a change in the advance payment. But you can correct me if I'm wrong. But this is what is in front of him. But you can correct me if I'm wrong, Minister.
Thank you very much, Chair. Chair, you are absolutely correct that is the position of Smart Infraco. But that's why I started by saying that this is not about what Sam George's position is or what Smart Infraco's position is. It's about what the position of the law is. Nobody has said that addendums to a law, to a contract are illegal. I have never made that claim here. Addendums are a legal part of the legal process of contracting. However, the question we're raising is that when addendums change substantially what the original contract was, we have chosen to subject that to the Attorney General's advice. And that's why I'm saying that if today you have a report which we are not privy to, the document you reference as a response from Smart Infraco to the committee, we haven't seen at the ministry. But if in that they admit some liability, it comes back to support my initial submission and position that the 6 million ought to be paid to the states. When that is paid to the state, they can make whatever claims, because let's not forget, the claims are now being made on the back of the addendum. Not because the parent contract says that all the cost and risk should be borne by the private entity. Now they are saying that the addendum allows for them to move that liability to government. Because that's why they are saying that they don't owe 6 million. The cost that they claim they spent in rectifying the infrastructure is the reason why in their response to you, I want to believe, they are saying that liability is not 6 million, but 1 million and about 160,000 if I heard you right, Madam Chair. And so that's why I'm saying that claim must be submitted. That claim cannot be made by the private entity and then say that we have decided that government owes us this, so we are deducting it from government's money and this is what we will give. No, that power does not rest with a private entity.
As for that one, I agree with you 100%.
So for reading Ankasa Suma, through the committee and confusion kakra the echo so just say utim say report kuta some NPP MPs our multi committee so no is different from a report kuta the ministry. How come say a whole ministry the report a different from a parliament committee, Minka parliament committee, some NPP MPs, and no more kasa say I in the name of the committee no, and the JSR report no. Meanwhile, Momoje report no, Momo presented the report no Emma the ministry, Emma ni hwehwemu. It was okay. Obey some reconciliation concerning the previous report I could tell me. Any the current report among said sa companies here or mudin war this Ṣcandaļ mono. Bit my issue say errors over her because there are more errors and say you compare the two reports. And any pamino they are crying say any pamino ways so no. Omoka leaders of the committee no and omonikuta this document speaking in favor of the that company deals money ßļasts then on the minister of communication and the ministry no sa company me no deals some year no more NPP MPs way and more kasa just sema just so as we speak in there, yeah, Sam George, say, on what to speak in favor of some company. On what as we speak, no, near my course that ministry no, corner or Akroma sign man happen. That's your drag is to this communication. Also on what to speak in favor, to make any deal to affect Ghana. He is in the position to speak in favor of Ghana. Ghana first. So if say Auditor General report at the Auditor by Abraham Parliament, Mosi emfa eye Auditor General report in 20. Me che MPs na no mu defend sa companies no. Yemfa Auditor General report in 20. Ni dealing with company now no eye the center of this case and as a scandal no. Yemfa mo manum no. Yemfa justification how. And I think Kebeka crack yemfa the ministry information no. Community on information in Nekutano. Yemfa ministry information no. I report mom and casam. And can for the general report in 20. But yinti mean for no one. The Auditor General report and Nekuta all the report concerning all these documents. The previous government near my deal some year no Nekuta nina. O my hwehwemu say company ABCD edeka $6 million. Omudika say more as MPs MPs are multi committee no so no. Mosi for Auditor General report in moment 20. Na company na mum na mosi as a letter come in the name of the committee no. Mo so kwa na report ni bitamo. Yen use san company no menu masam. Ninja 1 ministry na nu masam. 2 we plan no Auditor General onu menu masam. How? That's where I did some little confusion by committee no so. I just say we still some George I say money bufu kakra. And my chair say there's no way if some company be doing say your cassette and any individual doing say or my cassette they can go to court. But as you speak it there, the Auditor General can hear because that committee now ßļasts say they probing no, they are probing in the name of Auditor General report. The Auditor General report in Hishuma Wakoyeno and a sa committee we a probe. And yes, I'm committee we to deal with some company B. Onumasam and report into Matisa a committee we. Auditor General report into a committee we mind at a government a discarding a supporting. So Maba the Auditor General report can or not as some George and no what and yet the mum says mukuta some different report or no class some George own no one be and I'm already channel. He tried to convince the chairman of the committee. I'm a chairman of the committee near them and say Ampa. Auditor General report internet here. So we need reports aside Auditor General report no. Nina bugos in fan 20 yen deal with the matter. If say Auditor General report say yen refunded some money or say refunded. If say some legal cases be oma Attorney General simple. Yen forget the air company then. Report na NPPMP's phone kwanso na edi kutomo. I just wa boss has ni nyina de atu gwanya asenketo. Yeah, committee no so I she pa. In na video no bit ma share down the comment section. Subscribe na share man so nya bintia for once in Akroma.